Good morning, everybody. Thank you very much to everyone who has attended on time. We're a little bit down on numbers so far, so I'm just going to wait for another 1 minute or two at the absolute most before I start. We've got quite a lot to get through, so I won't leave it any longer than that. All right, well, our numbers are still creeping up, but as I say, we've got a lot to get through, so I'm going to make a start. And like to begin by saying, on behalf of all of us here at Oracle Law Global, very warm welcome to this webinar on the future of our beloved EU 261 regulation and the changes that are now imminent to it. A couple of little bits of housekeeping just to get through before I make a proper start. Number one, this seminar is being recorded, and the recording, like the slides, will be made available afterwards. So if any of you are worrying about having to keep up with notes, please don't worry. It'll all be there on screen for you afterwards. Secondly, as you can see, I think from your interface, there is a Q&A function available to you all. Please feel free to submit questions as we go along, although I won't deal with them until we get to the Q&A session at the end. For those of you that I haven't had the pleasure to meet already, this is me. I've been practicing as a barrister for 20 years this year, and I've started asking myself, where did the time go? Well, 9 years of it has been spent here at Oracle Law Global, specializing for practically all of that time in aviation law, with a strong focus on consumer rights claims against airlines and exclusively representing the airlines in that capacity. And that's involved me leading our teams across the UK and the EU, handling everything from individual EU 261 claims at first instance, all the way up to strategic litigation up in the national Supreme Courts in the UK, Germany and Italy, and also in the CJEU. And in the course of that, becoming more familiar with EU 261 than any well-balanced person would ever wish to be, which I hope stands me in relatively good stead to tell you about how it's changing. A quick outline before we go any further about the course that we're going to follow through this webinar. We'll begin by going through very briefly the path to reform, how we've got to where we are and what the timeline is for these changes to be implemented. And I'm then going to go through what I think are the 5 most significant changes to the EU 261 regulation. There is nowhere near enough time in this hour to go through every change. I've had to leave a lot out, not just cosmetic changes, but some that are substantive. But I've chosen to focus on those that I think have the biggest, or at least the broadest impact, and are going to affect the largest number of airlines, irrespective of their market position and business model. And briefly, those are the changes to how extraordinary circumstances are described and defined in the regulation, the changes to the procedure for rerouting offers, and in particular to the process for passengers claiming reimbursement of their self-rerouting expenses, big changes to how compensation is requested and claimed by customers, and the accompanying duties on airlines to state the rights and inform passengers of their compensation rights. The rules relating to personal items, newly defined class of items that passengers are entitled to bring into the cabin free of charge. And fifthly, little bit of a cheat in that it's a collection of small changes rather than one big one, but a number of new prohibitions in the regulation, which I've chosen to collectively describe as the play nice rules, and we'll see why that is when we get to them. Periodically during the course of that, I'm going to put up this little question mark icon on the screen, and that's there to show where I think the new wording is ambiguous or throws up an open question that is going to have to be answered by the national courts or by the CJEU. I'll do my best when I can to indicate on the basis of my experience what I think the answer to that question is likely to be. But of course, that can only be a matter of opinion. And until somebody in a robe gives a more authoritative opinion, it will be open to question. Once we've explored all those, I'll talk a little about what I think overall the likely impacts of those changes are likely to be on how airlines respond to EU 261 entitlements and on how CMCs are likely to respond. And at the end, I'll try and deal with as many questions as I possibly can. So, the path to reform, how did we get here? Some of you who've been in the business a long time will no doubt remember that as long ago as 2013, the European Commission proposed a suite of amendments to EU 261, really quite modest, largely aimed at codifying the case law as it stood up until then, although it did also include a few substantive changes like pushing back the qualification of a qualifying delay from 3 hours to 5. That then went to the European Council, which proceeded to seemingly, from an outsider's perspective, do absolutely nothing about it for about 12 years, until coming up with some proposals in the middle of last year, which were not dissimilar, but also included some changes to the claims process. That went to Parliament, which in January of this year produced its own amendments. I put amendments in inverted commas because really what they did was to rip out practically the entirety of the Council's proposals and replace them with, frankly, a Frankenstein regulation that looked an awful lot like the product of a process where every single member of the Transport Committee had been allowed to put in their own personal pet project or hobby horse. It was relentlessly pro-consumer, or one might even say anti-airline, and included some extremely adventurous and frankly unworkable proposals, like getting rid of any defence to a denied boarding claim on the basis of reasonable grounds, and also extending the regulation to apply to non-community carriers flying into the EU. The Commission responded to that in March of this year, very politely telling the Parliament that many of its proposals weren't going to work and were unenforceable, and that resulted in the conciliation process between the Council and the Parliament, which resulted in an agreed text in June last month, and that's where we are now with that agreed text. It's received parliamentary approval as of last week, and so now the remaining steps before this becomes law are formalities, although they will still take another few weeks to be completed. But the end result of that is that that agreed text, which is what we're going through today, is going to enter into force. We can say that now with something approaching absolute certainty, and we're expecting those changes to be effective in the third quarter of next year. We're not sure about that, could be a little earlier, unlikely to be much later, but our ballpark estimate is that they're going to come in around August or September of next year. So what's in the new reform package? Well, the first change is to do with extraordinary circumstances. Those are now more expansively defined within the regulation itself, with a new definition put in at Article 2. Nothing surprising or controversial about the definition. It picks up the definition of extraordinary circumstances as it's been developed in the case law from Valentin Herman and onwards. But what is new is this provision at Article 6C. There is now going to be appended to the regulation an annex listing extraordinary circumstances. It will be non-exhaustive. In other words, if it's on the list, it's an extraordinary circumstance. If it's off the list, it still might be, but you have to argue that from first principles. Worth bearing in mind, Parliament wanted an exhaustive list so that you couldn't argue about anything that wasn't on it, but the Commission rejected that and it hasn't found its way into the agreed position. I picked out what I think are a few items of interest from the list of things that are now deemed to be extraordinary circumstances. Disruptive passengers. There have been cases before when disruptive passengers have been deemed to be an extraordinary circumstance, so it's not in itself a surprise to see it on the list. But I am surprised by the end of this paragraph. It won't be an extraordinary circumstance if the operating air carrier causes the occurrence of this behaviour. I wonder what is the use case for that qualification. If you serve alcohol on the plane to somebody who had already had a few and they become aggressive, have you lost your extraordinary circumstances defence when you have to divert in order for them to be taken off by the police? What about if your customer service doesn't meet expectations and passengers lose their temper at the airport and then aren't allowed on the plane? Can they say that you provoked them into losing their temper by failing to answer the phone or the web chat? We'll have to wait for some cases to see, but that does seem to be the sense of what that element of the annex says. Passengers who fall ill and have to have the flight diverted or delayed while they're taken off the plane before it departs. Interesting that it's on the list simply because, whilst we might all think that's an obvious example of an extraordinary circumstance, I'm aware of at least one ADR body that takes a different view and has been routinely ruling in scores of cases that because passengers are so integral to the activity of an air carrier, that them falling ill is not an extraordinary circumstance any more than it is when it happens with your flight crew. So they've been effectively overruled on that point by the inclusion of that in the annex. Air traffic management decisions, of course, those were already deemed to be an extraordinary circumstance under recital 15 of the regulation as it stands. No surprise to see them featuring on that list. But again, slightly strange choice of wording at the end of this provision. You've got to show, provided that the event results from a decision that was beyond the actual control of the operating air carrier. Strange wording because, by definition, the decisions to impose ATMDs are taken by ATC, not by the airline, and they're not taken at the request of airlines. So what does that mean? Well, I think the answer is it's supposed to reflect a principle that comes out of the case law as it is. If you do something that causes ATC to take the decision, for example, something falls off your aircraft onto the runway and ATC decides to close the runway as a result, then you can't hide behind the ATC decision. It has to arise from circumstances that you didn't create. But to say that it has to arise from a decision that you didn't take or didn't have actual control of is unusual wording. But I think that is the answer to it. We'll have to see if I'm right. Strikes at ground handling service providers are, at first blush, something that it's very exciting to see on this list, because it's not uncommon. And this is a real bone of contention with ADR providers and the courts as to whether or not it constitutes an extraordinary circumstance, or whether you're liable because ultimately they're part of your business that you chose to contract out. I say at first blush because when you read that provision, it cross-references to Directive 96/67, and it applies only to those ground handling service providers that you don't effectively choose. Now, that has a technical meaning within that directive, and without going into details, I think the result is that this deeming provision is not going to apply very often, and it will only apply to smaller or newer airports and not to the larger or longer established ones where there's a relatively free market in ground handling. But worth remembering that just because your strike doesn't fall within this provision in the annex, because the annex is non-exhaustive, doesn't stop you arguing that it's still an extraordinary circumstance, arguing from first principles, not inherent and beyond your control. Let's look at how reasonable measures are now dealt with in the text of the regulation. Recall how the regulation as it currently stands phrases the issue. Extraordinary circumstances which could not have been avoided, even if all reasonable measures had been taken. That is a retrospective hypothetical. And that means that under the regulation as it stands, it's possible to argue that you have a defence, even if you did not take all reasonable measures at the time, provided that you can now show that even if you had, it wouldn't have helped. That now appears to have been ruled out, because look down at the sentence or the phrase that I've emphasised at the bottom of this paragraph. You now have to prove direct causal link and that the air carrier has taken all reasonable measures to avoid the disruption. That's not a hypothetical. That's about saying that you did at the time everything that could be seen at the time as being reasonable. This is a particular issue in relation to rebooking customers, which, as we all know, the CJEU thinks is a reasonable measure in both delay and cancellation cases. It's commonplace, in my experience, for airlines to not do that at the time or not do it well enough. And then later at court to produce evidence, which we can help them with, that says, well, look at what the ticket prices were. Even if we had looked at other carriers, we couldn't possibly have afforded to rebook them, or there weren't any flights available. Most courts, because it's a retrospective hypothetical, accept that that's a legitimate way of advancing your defence. Some don't, but most do. But this appears to rule that out. Based on this change to wording, it looks as though if you didn't look at the time or didn't look well enough at the time, you're out. You've lost your defence, even if you can show later that it wouldn't have helped. The second change that we're going to look at is the change to rerouting under Article 8. And as I'll remind you in a moment, that's distinct from rerouting as a reasonable measure. Of course, the requirement to offer customers whose flights are cancelled the choice between a refund and rerouting is still there in Article 8, but it's been refined a bit. And in particular, the regulation is now express about what has to be in the offer that you make them. Subject to availability, it says you've got to offer at least one of the following. And here's the list. A flight on the same route, presumably at a later time or perhaps even an earlier time. A different routing between the same airports. They obviously have in mind connecting somewhere or with a different connection, or rerouting to and from alternative airports. I'll put a box around those because nothing controversial about those. Those are what all airlines are doing already, or at least know that they should be doing already. But the others on this list are a little bit new. Use of services operated by another air carrier. That's never been an Article 8 requirement up until now. It has been a requirement for rerouting as a reasonable measure, but not under Article 8. And where appropriate for the distance to be travelled, the use of another mode of transport. Now, this throws up some questions. And the reason it throws up questions is because thanks to the CJEU's earlier rulings, we already have a confused picture where it's possible in both a cancellation case and a delay case for an airline to incur two separate, parallel, coexisting rerouting duties. In a cancellation case, at least, you can have a rerouting duty under Article 8, and you can also have a rerouting duty as a facet of reasonable measures, but they don't have the same tests. The reasonable measures requirement is qualified in the case law by the concept of intolerable sacrifices. A measure won't be reasonable if it imposes intolerable sacrifices, and that clearly imports a cost consideration. But you could also have a duty to reroute under Article 8, and Article 8 says nothing about cost. All it says is comparable transport conditions. Does comparability include an element of cost? Not clear, because the legislator didn't know that there was going to be rerouting as a reasonable measure. And far from resolving that problem, this amendment now appears to have introduced yet a third test or qualification on the duty, availability. Well, it's welcome to have an availability test for rerouting, but does that allow you to factor in cost into what you offer? It's not a normal use of language to say that it does. I mean, a brand new Rolls-Royce is technically available to me. I just can't afford it. So one would not normally say that it's unavailable just because it has a cost problem associated with it. Perhaps the saving grace here is that you don't have to offer all of these. The new regulation is saying you have to offer at least one. There's now clarity about when you have to offer rerouting. When a passenger responds to the Article 8 offer by choosing rerouting, you've got to offer the rerouting options within 3 hours. And of course, that's got to include at least one of the options that we've just looked at. It's also now clear that if the passenger doesn't like what you've offered and he or she decides to go their own way and reroute themselves, they've got to tell you. Now, that's quite helpful because, of course, it can give airlines the opportunity to head off what could otherwise be a very expensive self-rerouting claim by saying, sorry you didn't like our first attempt to do this, but before you go your own way, let us try again. We might be able to do it cheaper. But what's not clear here, what happens if the passenger doesn't tell you? Is it a condition precedent to their later being able to recover their expenses from you by way of a self-rerouting expenses claim? Or is it just directory, and does it just give the airline the ability to complain against them argue about the extent of the costs and maybe argue they shouldn't have to meet legal costs if it ends up in court. To my mind, the more natural reading is that it is a condition precedent, and if they don't tell you that they're about to self-reroute, then they can't get their money back. But that's just an opinion as to how that wording reads to me, and the answer, I'm afraid, is going to have to come from a court. There is now a cap on the total amount that customers can recover if they self-reroute, and it's 400% of the full price of the tickets, including any travel agent fees where applicable. That's going to be particularly useful to low-cost carriers, particularly when there are mass disruption events and they're faced with having to route very large numbers of customers who bought tickets well in advance for very cheap prices, but for whom reaccommodation on other flights at short notice or on the day is now going to be very expensive. The third change, and I think this is the most consequential of all, is to the process for claiming compensation. Articles 5 and 6 have new wording. Those are the ones that trigger the compensation entitlement in cases of cancellations and in cases of delay. They now say this: passengers shall have the right to receive, upon request, compensation from the operating air carrier of the cancelled flight. I think that is a big deal. And the reason I think it is a big deal is this. Under the regulation as it stands, the right to compensation crystallizes, accrues, vests, however you want to say it, is complete at the moment of the cancellation or at the moment of the customer's arrival, subject to any extraordinary circumstances defence. Now, that right hasn't completely formed or vested until a request is made to the air carrier. And that is a substantial difference. It makes a difference to limitation periods, but also, as we'll go on to see when we look at the request mechanism, it might well make a difference to how CMCs are able to be involved. To counterbalance what might seem to be a disadvantageous change to the customer, the legislator has chosen to include a tremendous number of new layers of information requirements, obligations on the air carrier to prompt customers to consider requesting compensation and to inform them of their rights. The first one is in the rewritten Article 14, and this is the least onerous of all of them, an obligation to display on your website and on your mobile app. So an update to the old check-in desk specification under the regulation as it stands, a notice of rights. You can use a model supplied by the European Commission, so not very problematic there. But now let's look at what happens when there's disruption, and this is when things get tricky. If you cancel a flight, you now have an obligation to immediately, note that word, immediately, inform the passengers concerned. You have to not just give them their Article 8 choice, but you then have to inform them of the process for requesting compensation defined in Article 7 and on the handling of complaints. We'll come on to look at both of those. And you have to specify to the passengers concerned the reason for the calculation. It doesn't say you have to go into any great detail, but you must at least specify why your flight has been cancelled. And bear in mind, this has to be immediate on cancellation. So not quite as easy as you might think to just make that simple statement about why. There's parallel provision in respect of delays. You've got to tell them by at the latest the time of departure indicated on the passenger's ticket. Well, no one seemed to think of the fact that sometimes delays happen after a timely departure due to diversions or whatever. But even so, same requirement to state the reason for the delay on departure or arrival, state it effectively immediately, and give information on the process for requesting compensation. But then we get this in Article 7. Where a passenger may have a right to compensation, the operating air carrier shall, within 96 hours of the termination of the journey, provide information on the passenger's compensation rights and clear instructions on how to submit a request for compensation. That's separate to the notification requirements we've just seen in Articles 5 and 6. It has a different deadline, but it seems to have much the same content. And one question here is, are you allowed to use the same communication to satisfy both requirements? If you put everything that you were supposed to put in the Article 5 or 6 notification, doesn't that also satisfy this Article 7 2A notification requirement? Well, I think it probably does, But would you take the risk, particularly since it's not clear from the wording whether or not a failure to do this might prejudice your ability ultimately to assert an extraordinary circumstances defence? And the second question, although I think I know the answer to this one, what about that phrase may have a right to compensation? If you're truly, sincerely convinced that they don't because you have a rock solid extraordinary circumstances defence, does that mean that you don't have to give this information? Well, I think we all know the answer, but I thought I'd mention the point anyway. What about requests for compensation? Those are now regulated by Article 7.5. And there's a few very interesting points to note in this, which I am sure are going to end up in court because of the enormous financial interests in play on both sides in having these resolved. So what are they? Firstly, look at this new time limit that starts at the end of the first line here. Requests for compensation have got to be submitted by the passenger within 9 months of the actual date of departure. The key question here, is that a limitation period or a prescription period, such as would have the effect that if a passenger misses the 9-month deadline, they've lost their right to compensation and it's extinct or never arose in the first place? I think that is what it means. I think that's the obvious interpretation of that phrase, but I will flag up the risk that the courts might see it differently. Bear in mind how loose the CJEU can be with the text of the regulation and how ready it is to apply the recital referring to a high level of protection for passengers. There is another interpretation available. And that other interpretation is that this is merely directory, saying when passengers should submit their complaints, but that it doesn't prevent a late complaint or a late court claim, that national limitation periods still apply, and that the only thing that that time limit does is to give the airline an argument as to why it shouldn't meet legal costs if the claim is late, or why it should recover its own legal costs and set it off against the compensation. I don't think those two arguments are equally strong. I don't think those two interpretations are equally plausible. To me, this is a limitation period, but I will flag up that I think that is going to be debated. I think it is going to be argued. I think it is going to be litigated. Perhaps more importantly, we have a question about CMCs. Note this. Where a request is submitted by a third party on behalf of passengers, the operating air carrier may require evidence of a valid mandate to act. Now, what's interesting there is the word valid. It doesn't just say may require evidence of a mandate to act. It says a valid mandate. But the new regulation doesn't have any rules in it that bear on the question of whether or not a given mandate is valid. So where do those rules come from? There must be some, otherwise the word valid isn't doing any work in that sentence. The rules have got presumably to come from national law that govern the activities of claims agencies or indeed any other intermediary or agent. Does that mean that the validity of a mandate can be affected by the contract of carriage? If it can, does that mean that those airlines that currently include in their terms and conditions a requirement that the passenger contact the airline personally in the first instance before turning to a CMC can now use that here to say, well, I've seen your mandate, but it's not valid, and so you cannot pursue this claim? Or what about the alternative argument, which the CMCs will undoubtedly say, that because this new Article 7.5 implicitly anticipates or explicitly anticipates that third parties will be submitting on behalf of passengers, that you therefore impliedly can't prohibit that in your terms and conditions? There's no way, in my estimation, that that's going to be resolved without litigation. But another interesting point that arises out of that, what about assignments? There are plenty of CMCs that currently operate on an assignment model where they buy up the customer's claim and then they present it to the airline in pre-court and, if unsatisfied, in court as their own claim. And to me, based on this wording, it's an open question whether they can still do that. The reasons why it's an open question are this. Firstly, given that the right to compensation now only crystallizes or vests as a result of the request being made to the airline, what is there to assign before that request has been made? Only an incomplete right, a possible future right. Well, some legal systems allow an assignment of rights that haven't yet accrued, but some don't. So that might pose a problem. But I think more particularly, look at the wording here. Who does the article say has to submit the request that gives rise to the entitlement to compensation? Must be submitted by the passenger, or a little further down, by a third party on behalf of passengers. An assignee doesn't fall into either of those categories. They're not the passenger, they're also not acting on behalf of passengers. If their assignment works, they've acquired the compensation right. It's now their property. They're acting on their own behalf. So they don't fall into either of the categories of people who this article says can make the compensation request. And they can't go straight to court because without the compensation request, the right hasn't accrued. So to me, it's an open question whether the assignment model still works under Article 7. They may well say, well, if you look at the CJEU's jurisprudence, event media, for example, it's clear that the CJEU thinks that EU 261 compensation should be assignable, and so you've got to read those words into Article 7. The counter-argument is, well, this article postdates that case law, and if it is different to it, then it impliedly overrides that case law. Quite big stakes here financially, so again, I don't think that question is going to be resolved without litigation. What if you receive a request that you think you've got a defence? Well, you've got to give a fully reasoned reply. You've now got to tell the customer, in answer to their request, which of the extraordinary circumstances you're relying on, and if it's not one that's on the list, you've got to explain why you think it's an extraordinary circumstance, applying the Valentin-Herman test. And as you can see from the part I've emphasized lower down this paragraph, you also have to state your position on reasonable measures. Not just saying, oh, we did take all reasonable measures. That's not enough. You've got to explain how the measures you took were reasonable to the situation. That means saying exactly what measures you took and why you didn't take the ones that you didn't. Now, this is all the sort of argumentation that airlines are perfectly used to putting forward at the court stage. But it's only a minority of customer claims that ever reach court. We all know that. This is bringing forward all of that workload from the court stage of the claims journey all the way forward to the customer service stage where it's going to apply to a very much larger number of claims. And that seems to me to be a big change and a very expensive change in terms of the administrative and cost burden of airlines in responding to those early requests. Those 2 or 3 line, sorry, it's an extraordinary circumstance, those are not going to work. And again, there's no indication here what the consequence is if you fail to give an adequate reply. Are you prejudiced in your later ability to assert extraordinary circumstances? It doesn't say so, but it doesn't say not, and that creates risk in my view. If the customer's not happy with your response to the request, they can now submit a complaint under Article 15A. And that's not an external complaint to an ADR provider or an NEB. That's a complaint to you, to the airline. You now have to set up a complaint handling mechanism. And I expect in many jurisdictions, the NEBs will want to see what your complaint handling mechanism is, which staff are dedicated to it, what the rules are, how you make sure that they have some sort of independence from the original decision and don't just feel that they have to endorse whatever customer services have originally said. A complaint has to be submitted within 12 months. Again, question, what if they don't? To me, the answer here is clear. It's not a condition precedent. This is voluntary on the passenger's part. If they don't submit the complaint, or they're not locked out of going to ADR or to court. But I suppose you could raise it as a costs argument at either of those stages. You've got to acknowledge the complaint within 7 days, perhaps not too onerous. But then within 1 month, or 2 at the most if you get an extension, you've got to give a reasoned reply, which also has to speak about the bodies responsible for complaints handling pursuant to the regulation. And that is a reference to the outside bodies, to the NEBs. Reasoned reply, again, that's quite onerous because it can't just be a restatement, can it, of what you said at the request stage. It's got to be an explanation for why the customer's complaint against that initial response is found not to be admissible or not meritorious. So once again, that's a substantive reply and another layer of burden on the airline to provide information and argumentation at a stage much earlier than it's been used to doing it. So to summarize here, we've got multiple layers now of requirements in terms of informing passengers of their rights and responding to their requests. Summary on the website or the app, immediate notification with cancellation or delay, including telling them then about the complaints process and the reason for the disruption. Then your 96-hour claims process notification with no clarity whether that can be satisfied by the same communication as in the previous step. Then you've got to answer the compensation request with a fully reasoned reply that pulls forward all of that work you're used to doing at the litigation stage into the customer services stage. Then you've got your internal complaints that you've got to set up, and only then you still might have to deal with ADR and the court stage if the passenger still isn't satisfied. To me, collectively, this easily doubles the workload that airline customer service and in-house legal departments are going to have to put in to dealing with customer complaints before they get to the litigation or ADR stage. The fourth of the 5 changes that we're going to look at, personal items and hand baggage. It's had a lot of press, more than I think any of the other changes that are coming in. Well, the regulation now defines personal items as being those that either fit within the maximum dimensions stated or on condition that they fit under the seat in front. And it distinguishes them very clearly from hand baggage, which is defined as unchecked baggage, which is not a personal item. And it matters that there's a distinction between the two because the rules are different with respect to the two. Question for me here, who gets to decide which of those 2 alternative criteria are applicable to a putative or claimed personal item? Can the airline say, well, actually, the standard we use is that it fits under the seat in front? And unfortunately, all our seats are only 2 centimeters from the ground, from the floor, and so it's not fitting under the seat in front, and you can't bring anything on board. Or can the customer say, no, I only have to satisfy one of those conditions. I don't care that it doesn't fit under your seat. It's less than 40 by 30 by 15. And so I'm bringing it on and there's nothing you can do about it and you can't charge me for it. To my mind, the second of those interpretations is what's meant. It would be too easy for airlines to game the tests the other way round. And so I think that it's for the customer to be able to rely on either of those 2 criteria for what amounts to a personal item. Why that matters is because of the new Article 11A. Air carriers shall permit passengers to carry a personal item in the cabin and at no extra cost. What can I say about that? It's black and white. It's very simple. You shall allow it. No arguments. Slightly different in respect of hand baggage. Here there are some arguments. You shall, subject to the capacity of the aircraft cabin, permit passengers to carry a piece of hand baggage in the cabin. Well, we all know that it's quite commonplace for there to be capacity issues that result in some bags having to be put in the hold. And as we'll see, the amended regulation does contemplate that that might still continue. But a big change here is that when you're marketing your fares on your website before the passengers even started booking, you must by default display the price that includes the right to bring a piece of hand baggage into the cabin. You can still offer a lower fare for a customer who's willing to forego that right, but it can't be your default and it can't be what you show for the purposes of price comparison or advertising the cost of the flight. You've got to show the fare that includes the right to bring on hand baggage. Where there are specific safety reasons or capacity reasons or a change of the aircraft type since the reservation was made, the air carrier may require those bags to be carried in the hold. Bit of a question here, how routine can that be? Can you invoke it, say, on every single flight by saying, well, look at the capacity of our aircraft, look at the overhead bins, look at the number of seats there are, and the amount of square feet per seat. We can't take hand baggage without special provision and special fares. I don't think that's a viable interpretation here. I think this provision reads more like there's got to be some kind of exceptional occurrence, like an unexpected change to the aircraft before you can routinely say, no, we're not accepting hand baggage. But I think you can still say, in respect of those customers who are the latest in the queue, I'm sorry, we're already full. The bins are already full up. Yours is going to have to go in the hold as long as you're not charging them extra. And so lastly, we come to the fifth of the changes that I'm going to briefly take you through, and that's the so-called play nice rules. And I've called them that because really this is just a list of things that annoy passengers or customers, and that as a result you're no longer allowed to do because airlines haven't made a good enough case for why they should be allowed to do them. What they all have in common is that they all look to the customer like just an opportunity to make a few extra quid off them, or they look like things that are just convenient for the airline, and the airline doesn't care whether it's convenient for the customer. I'm not saying that is what they are, but that's how they look to customers, and I'm afraid that's why they've made it into the regulation. So here's what you're no longer allowed to do. You can no longer deny boarding or charge additional fees to a customer who takes the return flight on a booking, but who missed the outbound flight or didn't take it for whatever reason. You can no longer blame the airport when you get a compensation claim from a disabled customer who was let down by the special assistance people at the airport and didn't make it to the gate in time. Well, that is to say, you can't blame the airport in your response to the customer. They have a compensation claim against you, and you can't blame the airport in defending yourself against that. You totally can blame the airport later when you go and seek redress against them and reimbursement of your outlay from them, but it's no good to you when answering the customer's claim. You can no longer deny boarding just because the passenger turned up with a boarding pass that they printed out at home rather than one in a digital format. You can no longer charge customers if they say they want their boarding pass on paper rather than digitally. This is a bit crazy to me. You can no longer require customers to use your app or to have an account on your systems in order to get their boarding passes. Well, that does seem strange to me because surely it's part of your data security obligations, given the sort of personal data that's on the booking system, to have some sort of control over who gets the boarding pass, isn't it? But apparently you're no longer allowed to insist that they validate themselves through one of those two mechanisms. And finally, you're no longer allowed to charge customers for correcting spelling mistakes in their name more than 48 hours before the flight. All right, so we've surveyed what I think are the 5 most impactful changes in the regulation, and let's talk a little bit about the impacts. We've already spoken about some of the impacts, but I want to summarize the position as I see it. Firstly, I think there is going to be an increased propensity to claim. And that's because of the number of additional prompts and reminders that you've got to give, as we saw earlier, you've got to give to a customer who has a potential compensation claim, reminding them of how they can make that claim. I mean, it's a rule of life, isn't it? The more you remind somebody to do something, the more often they're going to remember to do it. And I expect that to happen to claims. Counterbalancing that, I think we'll get fewer stale claims because of that 9-month limitation period. If I'm right that it is a limitation period, I think that's going to obviously compress the cycle times of the claims journey and mean that you have fewer where you're having to look back as long as the national limitation period, which can be up to 6 years, let's not forget, and try and open up your archives, read reports from people who no longer work for you, and try to defend yourself against something despite the fog of time having fallen over the relevant events. So that's quite good, but it also has the side effect that you're going to have less time to prepare your case on these, especially bearing in mind, as we've seen, the bringing forward of the requirement for substantiation of your defence from the court stage all the way earlier in the customer service journey of the complaint. And for that reason, as we mentioned, a hugely increased administrative burden, I think, on airline customer services and legal departments to provide not just those standard form notifications telling everyone how they can claim their compensation, but the substantiated position about extraordinary circumstances and reasonable measures. The lawyers are going to have to get involved a lot early, internally or externally, to judge whether a given flight does have the benefit of a defence and whether the written substantiation of it is good enough. CMCs, I'm sure, are going to challenge the interpretation that I've suggested about what happens at the compensation request stage. Well, they're going to have to, because I think there are issues there which could potentially restrict them a lot, not least about assignments, but also the question that I raised about validity of the mandate and whether that's something that can be affected by the contract of carriage. I can't see any way that the open questions that I referred to there are going to not be raised in court. There is too much money riding on it for that not to happen. And that's one of many questions that I flagged up during here that are going to have to be resolved by the courts. I hope it's been helpful for me to give my opinion on which way I think they're going to go. Maybe I should come back and do this webinar again in 5 years and you can see how many I got right. But if I didn't get them right, I shall find that I have something else to do on the 5th anniversary. Anyway, thank you all very much for sitting through what was, I'm afraid, rather a dense transfer of information about the amount of stuff in the regulation, but there is a lot of it, and I hope you agree that trying to get through as much as possible was beneficial rather than being even more selective and trimming it down to 3 changes rather than 5. And the good news is we've finished with a quarter of an hour to spare as intended, and so I will take some questions. Bear with me while I read them. Okay, so I've had a question from Tolga concerning claims submitted by claims management companies under UK 261. So important to bear in mind at the outset, these amendments to EU 261 don't affect UK 261. And so unless UK 261 is similarly amended, there's now going to be a divergence between the two. The questions that you've asked are about CMCs repetitively filing pre-court compensation requests and whether you're legally required to continue replying to duplicate claims. Well, under UK 261 as it stands, there isn't any equivalent to the new request and complaint mechanisms that are being introduced into EU 261. And so the questions that you're asking are questions about UK law and how the courts will handle it if you don't respond. Generally speaking, if you just completely ignore pre-court correspondence, then you might be at risk of an adverse costs order when you get to court, even if you subsequently win the case. But as long as you've given an answer, if the other side keep bombarding you with requests after that, you're not required to go back to them every time and say, look, I've already told you what the answer is to this question. You can tell them that you're not entering into any further correspondence. And I find it hard to believe that any judge would think that you were unreasonable in doing that. There is no express requirement in EU 261 claims in UK law to give a response at all at the pre-court stage. And the only reason to do so is to avoid a judge thinking that you've been unreasonable. But in the scenario you've outlined, you're not the one being unreasonable. And I wouldn't have any concerns about you telling the CMCs that you're no longer going to respond to repetitive correspondence relating to the same customer claim. I see you've asked a question, is there any remedy or enforcement action available to you to stop that repetitive and unreasonable conduct? Depends on the nature of the CMC. Non-law firm CMCs are not regulated insofar as they do EU 261 work. So there isn't anyone that you can complain to in relation to that. Although if they go far enough, you could always potentially look at getting an injunction to stop them harassing members of your staff. It would really have to be quite extreme before you could do that. If it's a law firm, then much different rules apply because they're regulated by the Solicitors Regulation Authority. And it might be possible, again, in a serious case and after due warning, to report them to the SRA for unprofessional behaviour. All right, another question. Is a passenger required to submit a compensation claim before filing a complaint under Article 15A? Under, for example, Polish law, the limitation period is 1 year from the date of the flight and may currently be suspended for up to 30 days while a complaint is being considered. How will the new 9-month deadline for compensation claims and the separate complaint deadlines affect this limitation period? Okay, well, my interpretation is that if the complaint under Article 15A is in relation to a failure to pay compensation, or is the customer saying I'm owed compensation, then it has to follow on from a request under Article 7. And that's because that's what the regulation says. The compensation is payable on request, not on 15A complaint. Might be an argument rather, that you have to construe something that's titled a complaint as being a request for compensation and deal with it accordingly. But even if you do, it still means that your compensation, that request is subject to the 9-month time limit. My reading of the amended article is that 9-month time limit is a substantive limitation period. I don't think it's a close run thing interpretatively. I think that's by far the more natural reading of the phrase. And if that's right, then it is overriding the national law limitation periods, which previously were applied to EU 261 compensation. And there is a rational reason why the legislature would want to do that, because those national limitation periods differed from one another massively. Some jurisdictions, it's as little as 6 months. And in other jurisdictions, it's as long as 6 years. And given that the objective of European regulation is to harmonise passenger rights as far as possible and not discriminate between citizens of different EU states, there's every reason why they would want to harmonise the limitation periods, and perhaps should have thought of doing so in the original regulation. So I think the natural interpretation, this is Carol's question, sorry if I didn't say so before, is that overrides the Polish 1-year period. All right. Question from Alberto. Hi, Harry, thanks for your presentation. The new text introduces a 9-month period for submitting a complaint. What's the relationship between this new limitation period and the national limitation periods applicable to claims under the regulation? Is submitting a complaint to the airline a mandatory prerequisite for bringing a court claim? Is the 9-month period intended to be a limitation period, prescription or forfeiture period, decadence? To my mind, it's a limitation period. And as I've said before, I think that's the most natural reading of the text. And I think you cannot qualify for compensation if you haven't made the request within 9 months. But as I flagged up, there is a risk that the courts might see it differently, applying the overarching objective of the regulation to provide a high level of, I mean, we all know what that recital says and how the CJEU likes to use it. So I will flag that up as a risk, but to my mind, the natural interpretation is that it's a limitation period. Question from Brona. Harry, does the right to bring hand baggage on board subject to capacity strictly mean bring on board as opposed to including free check-in for the bag? So if the fare includes the latter, can that be displaced as a default fare? Okay. I don't think you can operate that as a policy because of the way that new article is phrased. But what you are allowed to do is to invoke the exception built into the test, which says subject to capacity. So, but I don't think that you can invoke that exception before you know that you have a capacity problem, which you won't know at the stage when you're allowing the customer to book the flight. To me, that's something that you can invoke at the gate when you realize that you're already going to be full up, and something that the passenger was going to bring on board is now going to have to go in the hold as checked baggage, obviously without a fee. But to have that as an express overt policy at the start, where you say, just because we're calling it baggage doesn't mean you can bring it on board, we're just checking it in for free, I think you'd be at risk of being found to be in breach of that term. High risk. Question from Elena Sanchez-Aviles. Do you think the interpretation of all reasonable measures to be consistent with the principle of proportionality, particularly during network-wide disruption? Well, this is a question that we've all been asking and arguing since long before the amendment process. I mean, reasonable measures has been in the regulation since it was first enacted. And even though the word reasonable might be thought to be indicating a standard that's flexible and that is sensitive to conditions, including the enormous burden that can be imposed by a network-wide disruption, that doesn't help much when you get to court, as we know. It's very difficult to argue that there's something that you could have done, but it was unreasonable to do it because it was expensive. Even if in principle, anyone might be prepared to acknowledge that reasonability has got to take account of that. The reality is for most ADR providers, most judges, there is a loss. There is an inconvenience that's been suffered. And the question is, who is going to pay for it? Do they put that loss on the shoulders of the airline, who they are going to assume has deep pockets? They might be assuming wrongly, but at least compared to the consumer, they're going to think of them as a big business that can afford to cover this problem. Or are they going to put it on the consumer? The psychology is against you, and that's why, quite frankly, they keep moving the goalposts. Reasonable clearly doesn't mean what it means in most of the rest of national law. And the courts have been express about that. It will be reasonable as long as it doesn't impose an intolerable sacrifice. Now, as for proportionality, yes, the word proportionate is actually in the formulation of reasonable measures as it's been glossed by some of the case law. The problem isn't arguing whether proportionality is an element. Of course it is. The problem is actually getting a judge at first instance, in the context of an individual case, usually with some kind of horror story in front of them about what happened to a particular stranded passenger, to say that that's valid enough to excuse you from paying compensation to the person with whom he's likely to sympathize. It's not so much a legal problem as a presentational problem. And that's, I mean, one of the skills of trial advocacy is not just arguing about the law. It's about showing the judge why he or she shouldn't just indulge his feelings about the individual case, and why he should have a bit more sympathy with you than he perhaps would initially be inclined to. All right. I think I've answered all of the questions that have come in. We've got about 3 minutes left. If anyone wants to raise anything else, I'll just check my other window here. We have one more question from Jaime. If we link the obligation to provide a printed boarding pass free of charge with the principle that passengers should not be required to download or use an app in order to check in, would it be permissible to charge for airport check-in while keeping online check-in free through the app? In other words, could the airline maintain that its obligations are met because a free online check-in option exists, even if passengers who choose to check in at the airport have to pay a fee? Yeah, well, there's nothing in the new rules that I've seen that directly relates to checking in at the airport. That might line up with having a paper boarding pass, but it doesn't seem to me to be quite the same. So as long, bear in mind that to have a boarding pass, you obviously must have checked in. So the rules that we are looking at about paper boarding passes and the non-digital boarding passes, the self-printed out boarding passes, those all really assume that check-in has already happened and therefore must have happened online. Question for Sharina, from Sharina. Thanks, Harry. Do you think the increased notification or rights obligation is likely to be satisfied by directing passengers to carriers' websites for full rights details, as many carriers do now? Do you see a new requirement for everything now needing to be detailed in the email notification itself? Okay, that goes back to the definition of durable medium. And I haven't got it in front of me, but off the top of my head, I think the definition of durable medium is one that can be accessed offline and is therefore permanently available to the passenger. If you don't mind, Sharina, I will look at that again and I will email you about it. But I think the answer to your question is that for it to qualify as durable medium, it would have to be, say, there'd have to be something that's an attachment to an email or in the body of the email, which once it's been downloaded onto the passenger's phone or their email client, they're going to be able to look at again, even if they're offline. But I will double check that one for you. Question from Sajad: if we have live evidence to show that there were no seats available on the alternative flights or that the price was intolerable, will that evidence deal with the rebooking issue? Yeah, in my view, it will if it's live evidence, because the only way it can be live evidence is if you checked at the time. And if you checked at the time, then you did take the reasonable measure. What I was distinguishing that from was a situation in which you didn't check or didn't check widely enough at the time and then try to defend yourself later in court by saying, well, I've checked now. And the result of that is that even if I had checked earlier, it wouldn't have done any good. I don't think you can make that sort of defense anymore. But yeah, I mean, you're referring, Saj, to the service that we offer for live checking so that you can have evidence by the time you get to court. Yes, in my view, that absolutely still works. And in fact, it's now the only thing that works. All right, we are past time. I will just quickly check the chat to see if there's anything else coming in. Oh, question from Vincent Nicol. If there is a divergence between UK or EU 261, could we see an increase in customers' forum shopping? Yes, I expect you could for those flights that are in scope of both. And in particular, if I'm right about the 9-month limitation period, and if that then isn't replicated by amendments to UK 261, and bearing in mind the limitation period in the UK is 6 years, then there's going to be a massive difference. And I share your expectation that that's going to incentivize forum shopping. The only thing I disagree about is your use of the word customers. It's not going to be customers forum shopping, in my opinion. It's going to be the CMCs. All right. I think we have made it to the end of the questions, as indeed we have made it to the end of our hour. I would like to thank you all very much indeed for attending. Oh, question from Elena. Have I missed somebody? Sorry, Elena. I'm not sure. Can I unmute you? Oktay, can you unmute Elena? Maybe she wants to ask. Elena, I'm very sorry. I'm not in control here.
Apologies, it was a mistake. Sorry.
Okay, no problem. I was trying to unmute you and looking increasingly incompetent while reaching for the relevant control. Anyway, I'm afraid we are now out of time, but do feel free, please, to follow up by email. Reach me on Teams, reach me on LinkedIn, reach out to Oktay. Thank you all very much for giving up your time this morning to listen to me waffle on for just over an hour. And look forward, like the rest of you, to seeing what this new regulation brings us in terms of new issues in court. Thank you. Have a lovely 14 Juillet for those of you in France, and see you again. Bye.